And then we'll hit the stream live. If you can just double check it in a couple of minutes if you see us streaming live, just to make sure.
This meeting is being recorded. This meeting is being transcribed.
Thank you. Did you push? You pushed? Okay. Thank you and good afternoon. Today is Monday, September the 11th. This is the regularly scheduled Tennessee Athletic Commission meeting. It is 2 p.m. My name is Roxana Gamusio. I'm the executive director with this program. And before we proceed, I'm going to do a roll call vote to make sure we have quorum present and we can proceed. Dr. Christy Halbert.
Present.
Thank you. Ben Grove.
Present.
Thank you. Dan McGrew.
Present.
Thank you. Patrick Wren. Present. And Matt Reddish is not with us, but we do have quorum in order to proceed. Thank you very much, members. As you are aware, and we have teams also available always for individuals that want to join us online. Anyone from the public is able to provide comments as they relate to the agenda. This opportunity has been added to our actual agenda at the end of the full meeting under new business, so I will take a moment at that time to see if anyone's participating virtually and has any comments at all to add regarding the agenda. The first item of business that we have is notice of this meeting for the September 11th meeting has been posted on the website since June 14th of 2022. This particular agenda was posted on September the 6th. The minutes from our last meeting were added to emailed to all the members to review ahead of time. They are on your agenda for review. If you have any questions or changes that you see, please let me know. Otherwise, I would need a motion to accept the agenda as it's presented or with the amendments. I have a motion by Christy Halbert. Do we have a second?
I second.
And a second by Dan McGrew. All those in favor of accepting the agenda as presented, please say aye.
Aye.
Any opposed? Perfect. Thank you. The agenda as it's been presented, I would need a motion to accept that as well. And if there are any changes to add to the agenda, I welcome those. We can always, with new business, add anything new that we have there. But otherwise, I would need a motion to accept the agenda, please.
Make that motion.
Motion by Ben Grove. Do we have a second? Albert, all those in agreement, please say aye. Aye. Any opposed? Hearing none. Thank you very much. On your agendas, or in your iPads, I apologize, on page 5, we have the just about final numbers for our financial statements as of June 2023. One of the entries has been done. We have one or two more corrections often before the figures are finalized. This leaves the program with the loss for this last year that we just finished as an extra $25,953 deficit, leaving the program at $65,826 dollars in the red, and that would be our year-to-date amount. I know we've talked about the numbers at each of our meetings. We did have very good additional funds added in July as well as in August. So those funds are going to hit us for this next fiscal year. And they right now definitely will take us out of being in the red for the year-to-date amount as well. So we are very, very excited about that. And as the commission knows, we've made different changes, not just in new events coming in, but also in the way our field inspectors conduct and how many people we have at the event. So hopefully we'll start seeing a really good result from that. If you have any questions regarding the information, I want to make sure we always look at the financials to stay kind of on top of them. But I don't think I have anything else. This isn't anything we need to vote on. At the next meeting, we will see the final numbers as 2023 has closed. So if there are no other questions on that, I will turn it over to Jesse Gentry, our attorney for the program.
We do have one more UFC coming in this year, right?
Not that I'm aware of. They were here in August. I don't know that they're coming back this year.
But it was even there in November.
They are not on our records yet. That would be fantastic, but no, they haven't let us know yet. Thank you, though. Yeah. Jesse, it's all yours. Thank you, sir.
All right. We do have the legal report. I believe we have 4 cases on here total. They should be on your iPad. We can start with the first one, which is case number 2023031981. This was an unlicensed activity case involving what appeared to be an unsanctioned boxing event based on some advertisements that were received. Then, upon contacting the parties, it was essentially a professional wrestling match where they were going to have some wrestlers engaged in a wrestling type boxing event. They did change that and changed what they titled it as well. So, are there any questions on this case? Recommendation is to discuss with that company.
Question, what is an entertainment? It says 2 wrestlers in an entertainment match. What is that?
Essentially, I was trying to think of the most professional way to word that, but it is not an actual contest. They're not engaging in actual combat for a contest. It is like wrestling where it is scripted. Questions on this case, or would also vote on the whether or not you would like to accept that recommendation as well, or we can do them all at the end, whichever you all prefer.
Do them all to end.
Great, so we'll move to number 2, which is complaint number 2023030011, and this does involve a licensed boxer. Just summary there. Summarize it. There was a bout that was scheduled in June. The respondent did not show up for the weigh-in. The promoter had contacted him ahead of time and asked if he needed assistance. Well, the respondent actually told him he was not going to be able to make it there. The complainant, who was the promoter, stated he would drive him, also gave him options for having a ride to pick him up. And then at that point, the respondent stopped communicating, obviously did not show up to the weigh-in, did not show up to the contest either. So the recommendation is to authorize formal charges with an offer to settle through a consent order and a $250 civil penalty for his failure to give his best efforts. Are there any questions on this? Seeing no questions, we can move to case number 2023030261. This does involve a licensed promoter. And to summarize this, the complainant is actually a licensed boxer. He was injured during an event that was put on by this promoter, injured his hand. And something that's actually not in the summary, but I did go back and confirm based on our records. They did note as part of the conclusion of all of the matches that this boxer did need to be cleared by an orthopedic prior to resuming any other instances. So it does seem as if this is properly documented that the hand injury occurred during this actual boxing match. The complainant went and got x-rays. They put him in a cast and stated it was a broken hand. The respondent, the licensed promoter, is refusing to give the medical insurance information. He has stated that all expenses were to be covered by the boxer. On our side internally, we did tell the complainant he could make a public records request. Unfortunately, he is an out-of-state public records request for that medical insurance information from our office, since that's on file. The boxer is an out-of-state resident, so unfortunately he's not entitled to that as an out-of-state resident. If another Tennessee citizen made that request, they would be able to obtain that information. But based on the fact that he is unable to obtain a copy of that medical insurance. He filed this complaint, and my recommendation, because this promoter has refused to provide this information, my recommendation is to authorize formal charges with an offer to settle this matter by a consent order and a 6-month suspension of his promoter license.
How many events this promoter has done in the past?
Has done, I guess, at least one, just one. And we have had, I think we sent a letter of warning against this promoter previously. There was several issues brought up by our inspector team, and we felt like a letter of warning was the best way to address that issue. It was mainly, there were just too many people in the dressing rooms, which made it difficult for our inspectors to complete their job. And there is also another open complaint against this promoter related to his failure to pay his gate tax receipt. I've sent that offer to settle that case, and he has not accepted that offer yet.
How much time lapsed between that first event and this one?
I'm sorry, it's just this one event. So this was in February. So it has been 4 months. And the complainant has stated he's having issues with these medical bills, and that the hospitals are trying to send him to collections.
So I just want to make sure I understand. If so, the recommendation is for a 6-month suspension if the promoter does not comply.
Well, at this point, it would be a 6-month suspension, and if he complied, I mean, that would still be the recommendation. But we could certainly revisit this complaint at the next meeting in December if he did comply, and recommend to close it or to do a warning. But at this point, it's kind of a strange situation, but it seemed like this recommendation to suspend his license, it would prevent him from putting on more events for at least 6 months.
If he does not comply,
Does not, well, if he doesn't comply, either one, we can proceed with our formal charges, or he could accept the 6-month suspension. There's not a great mechanism to force him to give this information. The complainant has a lawyer and has threatened a civil action as well against the promoter. Certainly, if the commission wanted to consider, this was only a recommendation of a suspension. The commission could consider more drastic discipline, that could consider full revocation of his promoter license, could consider a civil penalty, or a suspension, or a combination of those. And at some point, too, I did want clarification, because I don't believe this commission has heard of a formal hearing, is my understanding. So if we did have a formal hearing, would you all prefer to have that before you all at the December meeting, or at some later meeting, or in front of an administrative law judge?
Well, if there was a formal hearing, the promoter would have to come before the board. Is that correct?
You'd have to appear, and certainly we would introduce plenty of exhibits regarding these issues that are at record.
Well, the 6-month suspension, that sounds fairly lenient to me. I mean, I would really suggest maybe 1 year at least for that particular type of infraction.
insurance is required.
That's correct.
So what's puzzling to me is if it is required and the promoter is carrying insurance, the point of carrying it is to use it. So if this promoter is willfully withholding of the insurance, that seems like a pretty serious offense, especially given what we all know can be very expensive medical bills on the part of the boxer.
I think if you add that to the fact that he's withholding his tax money from us, then it's like a double effect.
And this recommendation is just as part of the offer to settle this. So it is something where if he doesn't agree to that and this does become a formal hearing, the commission could then revisit that as well, hear all of the evidence. He could present his side as well, but so would the other witnesses, and the commission could decide on a different type of outcome as well, if it was something more drastic or more lenient. I think, we did discuss voting on all of these at the end, but if you would prefer to vote on at least this specific one at this point, I did hear Commissioner McGrew did state potentially a 12-month suspension. That is something that the board could vote on if they would like to have that as the decision from this case.
Patrick, pardon me, could I get you to press the red button so we got you? You got it. It did pick up your, thank you, sir.
Got new glasses, can't see colors. Anyhow, I believe from what I'm hearing, what I'm reading, we've got two problems. We've got one problem with a person who is not willing to follow the same set of rules that we kind of demand everyone else to follow if they're going to do business in our state. There's that. And then the second step is a collection problem. The guy owes us money. He owes money as a cost of doing business in our state. And he's kind of being real flippant, in my opinion, about paying it. And 6 months is like a missed slap on the hand, the way I look at it. There's got to be some thought given to a way that we can collect what is due our state. Okay? I mean, the man signed the papers, he joined the game, now he changed the rules afterwards. And so we got that, and then we've got the other part where throwing that up in the air and not going to get real concerned with the fact that he's walking away scot-free in his mind.
I would propose, based on the limited information that we have, this does seem like a very serious situation when we're talking about athlete health. And I know all of us on the commission take our role very seriously in that. So I would propose, or I guess I would entertain a discussion of a short window for the promoter to comply, given that this event, what happened in, was it February? So it's been a while. So we give him some short window, maybe 30 days, to comply with both of the outstanding issues. And if he does not, I could actually support an indefinite suspension on this.
I think we should vote.
Other thoughts on before we vote?
Second, the indefinite suspension.
So do I need to make a formal motion?
I think your motion, yes,
Okay.
and you can make it again, or I can help.
Formal motion to issue a letter, however that's done, electronic or written, for compliance, and alert the promoter that failure to comply will result in indefinite suspension. I guess we need to tack a fee, some sort of.
No, we did add a fee for the other
Okay, that's
complaint.
already
so that
occurred.
part
Okay.
is addressed.
Okay.
And one thing I do just want to make sure everyone's clear is this individual, this respondent, the promoter, does have due process. So if he, say it's day 31, 32, if he doesn't agree to that suspension, that would actually have to come through a formal hearing before the commission, likely in December. So 30 days from now, we're looking at the middle of October. So it's likely that at that point we would still have enough time that even if he didn't comply at that point, we could file our formal charges, get that on the calendar for the December board meeting or commission meeting. I'm sorry, but if that was the determination, I would like you all to vote on that, and then we can revisit the other cases that there were no changes for.
That's a motion, and did we have a second? And a second by Mr. Patrick Wren. Okay. All those in favor of the motion as it's stated by Dr. Halbert, please say aye.
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 Any opposed? Okay, case number 3 has been revised. Thank you.
All right, and then number 4, this will be the last case in the legal report. It's complaint number 2023036501. This is a different promoter, so it's not the same one as number 3. In this complaint, it was a promoter who filed this against this promoter who's the respondent, who stated that the respondent was obligated to pay for certain expenses, including the gate/ticket fee, as part of an event that these two co-promoted. When I went back to look at all of the records for the specific event that was in question, the complainant is actually the one who is listed as the promoter on the permit. So therefore, for our purposes, he is the one who is responsible for all of those fees. Even if they co-promoted that event together, that's a civil issue that they need to address separately. But that is why I recommended closing this case, because this respondent is not listed as the promoter of record for the event in question.
Does the respondent hold a promoter's license in the state of Tennessee?
Does.
Is it possible to put in an application for an event and have co-promoters? Is that a possibility?
I believe in
No.
our system, no.
Our system won't allow that. Yeah.
Fortunately, it does seem like this is pretty cut and dry. Would it be a possibility in the future for people to for promoters to co-promote an event?
We might have to look at our rules on that to then see. I think it would be an easy way to do it within our system. I think it would be more of a question about whether, lawfully we would be able to allow that.
So to avoid this in the future, the complainant would just need some sort of legal document between the two parties.
Right.
Yeah. Okay. Thank you.
If we revise the rule to allow for that, because right now it's just the promoter that's responsible.
Right. Yeah.
Whoever
If we do not change our rule, then both promoters would simply have their own legal document between the two of them.
Only one would be responsible for
Got
us.
it.
Yes.
They could just decide on their own,
Yep.
contractually to say, you're going to put up this, do all the fee, be responsible for all that, and they would just have to do that separately outside of our jurisdiction. There's no further discussion. I know we voted on number 3, but cases number 1, 2, and 4 from the report did not have any changes, so we can vote to accept those recommendations as listed. If there's further discussion.
I make a motion to accept the recommendations.
Thank you. Do we have a second to proceed with the recommendations as legal counsel has presented them for 1, 2, and 4?
I'll second the motion.
Thank you. We have a motion second by Ben Grove to accept cases 1, 2, and 4 as presented. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, that concludes the legal report. Thank you, Jesse. I'll leave it with you. The rule package starts on page 9 of your iPads.
And this item is mainly an update, but as you recall, there was a rulemaking hearing several months ago. This was actually held June of 2022 after some emails between the Attorney General's office and myself. They were signed by the Attorney General's office on July of 2023, submitted to the Secretary of State's office, and that rulemaking, or those rules that were addressed as part of that formal rulemaking, will go into effect on October 11th, 2023. Just to kind of bring you all up to speed again, because I know it's been a while since we've looked at this, but some of the major highlights, removing that 3 knockdown rule, removing the standing 8 count. That is something we've also discussed, making sure that we might want to send a letter out we've kind of looked at this between the executive director and I about if we want to email referees or promoters to let them know. I know when the referees are doing their pre-fight meetings, we do typically hear, this is Tennessee. Remember, we have our standing 8 count and our 3 knockdown rule. We have removed that for boxing. So that is something that is in line with the uniform rules through the Association of Boxing Commissions, and something that the industry might be I think, eager to know that that has changed. But most of the other changes from that rulemaking package, there were a few kind of outlining different fouls, different how knockouts are decided. So most of that is to add more clarity. But the standing 8 count and the 3 knockdown rule, I think that is probably the biggest change that we've seen from this rulemaking. Any questions about that? I don't think there's anything to vote on, but just more of we want to make sure everyone is aware that that will be changing. Right. And I believe we are set for the Joint Operations Committee, I think next month on that. It's in October.
September 20th.
Oh, that's right, September 20th. Okay, so we will be going later this month to bring the General Assembly information regarding this rulemaking. But everything is in line for that to go effective 1 month from today. Okay, so the next item on the agenda would be discussing proposed rules. And I believe you all received on your iPads a copy of the unified bare knuckle boxing rules. Earlier this summer, the ABC Commission, the Association of Boxing Commissions met and proposed some rules for the commissioners in attendance, or the executive directors, or whoever they have as voting designees in attendance, to review the bare knuckle boxing rules and to vote on them. Our assistant commissioner, Alex Martin, and myself, we both attended the meeting. We heard the discussion on the bare knuckle boxing rules, and the ABC Commission did vote to adopt those rules as presented. At this point, bare knuckle boxing still would not be supported in the state of Tennessee. I believe our rules would make those events still prohibited at this point. But if the Commission would like to decide whether or not they would like to allow those in the future, we could adopt those rules as written. We would have to set a rulemaking hearing. I have prepared things so that if we wanted to have that for our next meeting in December, we should be able to get the proper notice if you all would like to grant authority to grant bare knuckle boxing in the state.
Document starts on page 43 of your iPads if you haven't gotten to it yet.
Just for clarification, these are the rules that were approved by the ABC.
That's correct.
Thank you.
Two items I think that are very interesting to note from this. One would be that professional debut boxers are not allowed to debut in bare knuckle. They would have to have prior experience, and that there was no amateur bare knuckle fighting events.
straight, want to allow this into the state of Tennessee, we could vote to come back and look at this at our next meeting.
Yes. Essentially be voting today to allow or to authorize a rulemaking hearing at the next one. And if everyone voted no at that next hearing, we wouldn't move forward with it. But essentially, we would draft a rulemaking, the rulemaking documents. We would hold a public meeting for that. Everyone, the public would get notice of it. Anyone who's interested could appear to make public comments as well. And at that point, the commission would either vote to move forward with those or to deny it.
So we can vote now for a rulemaking meeting.
That's correct. So
Okay.
even if you voted to move forward with that, and even at that date in December, bare knuckle boxing still would not be allowed in Tennessee until everything is in effect. Essentially, just based on some of the review of the Attorney General's office, it does appear that it could be potentially. We'll go based on our last rulemaking, but it could be a year from now, potentially, is when it could be, even if you voted to move forward today.
If the any of the commissioners have any questions about this particular item?
Yes, sir. I've done a lot of research on this one.
Is there any more discussion? Are we ready to vote on this?
And I do think one more thing, it would be helpful to maybe vote on these separately. But I did also notice, after spending some more time looking through our rules as well as the unified rules, a couple other areas that we might want to address as well, just on other things within our rulemaking. Do you want to vote on this first, and then I can go through those since they are maybe a little bit separate outside the same scope? Okay.
Okay, we can do that.
Okay.
Okay, well, I make a motion to have a rulemaking meeting or our next commission meeting in light of having bare knuckle boxing the okay for the state of Tennessee to look into that.
Your motion to move forward with the rules as they're presented from the ABC?
It is.
I'll second that.
We have a motion by our chair, Dan McGrew, and a second by Christy Halbert to accept the rule that have been adapted by the ABC on bare knuckle fighting. So we will proceed with moving forward with that for a rulemaking hearing at our next scheduled meeting. All those in favor, please say aye.
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 Any opposed? Hearing none, we will proceed. Thank you.
Right, and then I did have 3 other items potentially to look at as well outside of the scope of bare knuckle boxing. One of them we've discussed, I think previously. I think the commission might have looked at this, but I did not see a record of it. But we've had some questions about the time limitations when a boxer or combatant suffers a knockout. Our rules specifically say 3 months or 6 months based on what they're allowed or permitted to engage in. And we did want to look to see if we could change that from months to days. So from 3 months to 90 days, 6 months to 180 days. I think it's a pretty minor change, but maybe it provides more clarity. So that was one item. The next one is I did notice we did remove the standing 8 count in specifically in boxing, but it was still in our rule for kickboxing. That's not in the ABC unified rule. So I did want to bring that to the commission's attention. That's something that could also be removed by those two. Third item would be regarding weight classes. On the ABC's website, they specifically have a page, I think it might be outdated, that shows weight classes that are in line with ours. But then when you go to the unified rules from mixed martial arts that was adopted a year ago from them, they specifically have the atom weight class, and the weight differential is a little bit different than what ours currently is. So I think that actually might be something where the ABC has not changed that necessarily on the website to match up where the weight classes for MMA are in the unified rules and then where they're specifically just listed as weight classes. But that's something that we could explore at a rulemaking hearing if we were to do both those together with the bare knuckle as well as that. I think that that is something to clarify those weight classes as well. Essentially, the atom weight class is anything up to 105 pounds. Right now, we would consider that straw weight. Anything up to 115 is straw weight. So there's about a 10-pound differential. You could have someone who is 100 pounds fighting someone who would be 115. That's a 15-pound difference.
I have also gotten some questions from fighters and coaches over the last year about how bare knuckle boxing would affect their sports, because there's been a lot of large worldwide promotions that do kickboxing and boxing events with MMA gloves, and that's sort of somewhere in between bare knuckle and MMA, and somewhere in between bare knuckle and regular boxing. But they do kickboxing that way, and there's also organizations in Florida that are doing bare knuckle in MMA. That's something we could.
Sure, we can look at that further. I believe from the bare knuckle rules, they do specifically say that you can't wear gloves. It's just tape on your hands for that. So I think that's we'd have to figure out what that would fall under. I think essentially if they're wearing MMA gloves for bare knuckle, that's not really bare knuckle at that point. There's also
the requests I've had were for kickboxing to be allowed to wear MMA gloves. So I don't know if that would be an amendment to MMA rules or boxing rules, or
I think they would go under the MMA and kickboxing rules.
okay,
Mm-hmm.
so that'd be a separate.
Mm-hmm. There are no other questions about those, or if there's any other rules that you all would like to propose to change or look at for this rulemaking hearing, I think now would be the appropriate time to look at that.
Back to what you were talking about, going from, if someone has a knockout, going from months to days, is that what you're saying?
Yes.
Just the verbiage. Okay, with the knockout, are you talking about loss of consciousness or TKO, or
I believe the way that we have it written currently is just, it says if it's just a knockout or a TKO. So depending on, obviously we have our, our standing 8 count would be a TKO or knockout, I'm sorry. So they wouldn't necessarily have to lose consciousness. They could just be judged as a knockout or TKO.
If the commission remembers, at our last meeting, it might have been March, not June, because you were here in June. One of our promoters actually spoke about that. He ran into this odd situation where someone he wanted to put in a bout had to be suspended for the 6 months, if I'm getting the dates right. But if we'd counted days, he would have been able to fight because of the way the months fall. And so he explained that, and he was right. I think we all agree that in most of the areas in our rules and statutes, we have number of days, but where we have months, the interpretation by legal is a month is, from June 5th to July 5th. It just is. You don't count the days. So I think that was the reason that moving everything to days where we could would make a difference. We've seen it happen once since I've been here, and I think one other time way back.
I think it makes sense just because then everyone gets treated equally no matter which month they got knocked out in.
I've been approached several times. I've encouraged them to send an email to Tennessee Athletic Commission, but I don't think that's been done. I think people prefer just to talk about possibilities, I guess, for rules. But what's been proposed to me is that since USA Boxing is a well-established governing body, and it is established as the sole national governing body for amateur boxing in the United States, that a sanction by USA Boxing automatically receive an amateur athletic event permit by our office. And I'm not sure how that would work, if that would be submitted by the geographical representative of USA Boxing, or how that would work exactly. But that has been proposed to me several times over the last 2 or 3 years.
And if I could ask, is that to simplify the permit process, to save money?
So it's twofold.
Okay.
One is certainly to simplify the process.
Okay.
Also to be in compliance. So we have 2 issues on compliance. One is the 30-day requirement, and some amateur events are coming together under the 30 days. And the other is that it appears that some amateur event hosts are still unaware of the requirement in Tennessee. So this would put the burden rather on dozens of people. It would put the burden of notifying the state. It would put the burden on the geographical president of USA Boxing. And so I believe, if I'm thinking through this correctly, I believe the Tennessee Athletic Commission would get more information about amateur boxing events than previous. It would be a more accurate representation of amateur boxing.
So if we move to add a rule to this, I'm just thinking out loud, under the amateur permit section, we would say that USA's governing body at a regional level would be responsible for applying for a permit however often, and list, I guess, who they're sanctioning. Does that sound right, or are they just applying one time and then whoever is going to be holding these events would just need to notify them?
Yes, so the geographical president of USA Boxing is responsible for overseeing the sanctions of local amateur events. So either they could notify Tennessee Athletic Commission on behalf of the sanction holder, or I guess we could come up with some other system. But the thinking is, in order to improve compliance and speed along the application process, I think right now it's required 30 days and
The letter, we need the letter from the,
yes, right, proof.
right.
And so if what we need is proof, and the geographical president has that proof, then maybe this would help with compliance if we got that directly from the president rather than the various sanction holders. But it would require doing away with the 30-day notice. That would be required.
And currently, we are able to waive that if there's certain thing, for certain reasons. And I think in a situation like that, if someone says, 10 days before the event, we just found out that, we finally got everything put together. We were waiting on different things to make sure we'd be able to hold this event. We probably could meet that requirement to be able to waive that.
And we actually do courtesy.
Right. And that's what I'm trying to I'm wondering if the geographic representative for USA or for any amateur sanctioning body submitted that application on their behalf, I just wonder, are they going to pay the fee or make sure that any of the other information from the promoter is provided?
So I guess rather than thinking of it as applying for a permit, it would be I guess more like a cooperation between Tennessee Athletic Commission and USA Boxing, in that the USA Boxing president would notify rather than apply for a sanction. The geographical entity of USA Boxing is a nonprofit organization. So by virtue of their sanction, I think that could satisfy the nonprofit requirement.
I think so. I think that's what would be a little bit interesting to consider, because typically we look at whether or not the promoter's the nonprofit. So, if it was sanctioned by USA Boxing, that they certainly would be the nonprofit. But if there was another promoter essentially who's still promoting the event and still, they're not a nonprofit if they're still making money off of it, I could see them getting around that. It is a low permit fee for that. So maybe it's not something where someone is really cutting corners and making out ahead on that. I almost wonder if it would be more efficient to have, instead of changing the rule at this point, but having someone from USA Boxing come to the next commission meeting and maybe discuss with the commission ways that they could cooperate, maybe not cooperate is the best word, but how we could all work more efficiently together with our sanctioning bodies.
Or maybe the December meeting.
And feel free to share my phone number, email, anything like that. That way we can get them on the agenda, know who's coming, and provide some information ahead of time, maybe for the commission to also see.
And that's something, we could discuss. Obviously outside of the scope of the commission staff, just general ways of what can we do to be, maybe there's issues or issues sport. I did pull back up the rule about gloves for kickboxing, just to make sure that we're not waiting for a couple months or for a later date. Where it is interesting, and this was actually a discussion at the ABC conference about individuals wanting to use UFC gloves for kickboxing. And it sounded like each commission kind of looked at it differently, but for our rule for kickboxing gloves, our currently says combatants in kickboxing contests in all weights up to including heavyweight shall wear no less than 8-ounce gloves. In heavier classes, fighters shall wear no less than 10-ounce gloves. When the two contestants differ in weight classes, they shall wear the gloves required for the higher weight. And then there's another rule that says all gloves must be approved by the commission. And then all gloves shall have padding over the knuckles. So I think it is something where the commission could, under the current scope, discuss whether or not they would like to approve USC gloves for kickboxing matches.
I'm not sure how they run it I know One Championships does it. I would assume they do shorter fights if they're going to have smaller gloves. But that's something that he better to y'all, or we can just.
I think that would be helpful. I think if they submitted that to us, and if it's something we need to take it to the commission for formal approval, we could do it that way. But I do think under the current scope of this rule, the way it's written, I think either we could look at it and then bring that to the commission for discussion. I don't see anything in here that would necessarily prohibit that. I know a lot of the UFC gloves already, when they talk about the UFC gloves in general, have to be under those same weight, those ounces anyway. So it should be able to comply with that.
So do we have, are we going to be voting on these particular items to discuss at the next meeting? Which items are?
I think it would be the changing of the months to days, where that appears in the rules. And I did only locate the one spot as it relates to individuals who are, have to be held out from matches based on previous knockouts. The change with the standing 8 count in kickboxing, and then the weight classifications to align with the unified rules for mixed martial arts. But unless there's anything else that needs to be discussed, those three, we could add that to the rulemaking hearing to discuss those and to discuss bare knuckle boxing.
Does anyone have anything else to add to that? You want to-
I do. I'm curious about slap fighting, and if we had a representative at the ABC meeting, was slap fighting discussed there, and what was the summary opinion?
It was discussed, and it did appear that it's not consistent across the commissions. I think it really goes back to how each state has defined basically unarmed combat. Based on our current statutes from discussions that I've had with the previous chief counsel as well as my supervisors, we've looked at it. We don't think that our current statutes would allow slap fighting, really because of just how boxing and other unarmed combat is discussed. I think it's something we could probably look at a little bit more if we wanted to have either legislative changes or find a way to see if it could comport more. It does seem like it's something that is being studied further, at least on the medical side as well, because there are, at the ABC conference, there were some discussions about whether or not it was safer, whether or not it was more dangerous, whether or not those injuries are different or similar. And right now, I think that there's a lot of videos out there of different slap fighting. I think they're a lot shorter, I think, than the videos are for a full boxing match. Part of it is because of the way that it's designed, but also just the way that things are shared on social media. So I think it's hard for people to probably study that until it's more mainstream. But I do know it's from the discussions, it's occurring in other countries more frequently. And then there are some jurisdictions where it's occurring in an almost unregulated manner. So I think there's a lot of civil liability that can occur from it, and there's a lot of potential injuries that'll be studied a little bit differently. It didn't seem like there wasn't a vote on slap fighting rules at the ABC Commission. It was more of a informational type session to discuss what is being done across the country essentially. But my understanding is based on our current legislative scheme, I don't think that we would be able to regulate that without further changes.
So do you want to add that to the discussion on our next meeting?
It might be something. I mean, if you all are getting questions about slap fighting, it could be something those individual. I mean, these are certainly, we have public comment and public meetings here. If they wanted to appear and address the commission, I think that would be the best way to do it, because certainly being a public meeting that could go to the General Assembly, other individuals could be put on notice of it. I don't know if there's much action that we could take on it at this point. I think some of that would have to come from the General Assembly. But I think if you're getting questions about it, maybe the best way is to invite them to appear at a meeting. It does seem like there are a lot of promoters who are doing that, where it's kind of a cross between, they also promote mixed martial arts, maybe they also promote some boxing, maybe bare knuckle boxing as well. I think it's kind of ingrained in combat sports. I don't think that it's a large variety of individuals who are only doing slap fighting. I think that it's a lot of the same type of individuals. But certainly not Tennessee in a regulated manner.
So do you want to add that onto our discussions, or?
Yes, I think we invite, if members of the public are interested in it, we invite them to speak to our commission. But if Dana White has purchased the rights to slap fighting, my guess is that this is going to come up sooner rather than later. So it may be prudent for us to already be in discussions about that.
So that would be like item number 4.
Well, I think invite them. We're happy to put that on the agenda. If there are people who want to appear and discuss slap fighting, I think we could have that as a further discussion point. I think that might be something maybe outside of the scope of the rulemaking at this point, because I think we really need to look, from my understanding, from the way that's been discussed and analyzed previously, it likely requires legislative change.
And if you are reaching back to your contacts, I think if it's okay with you, give them my phone number or name, or just to send me anything, just so we know that they're coming and we can put them on the agenda and allow for the time and so forth for those topics. And we discussed the conversations that you're having regarding the different gloves for kickboxing and rules. If someone does want to discuss the crossover, then that would be appropriate. Obviously, USA governing body and the amateur events, that sounds fantastic. So they can guide us on what they're really needing. And then the slap fighting piece, those would be, I don't know that we'll fit everybody, just depending on how much they want to present and discuss. It'll be a busy meeting, especially if we're having a rulemaking hearing. But definitely have it on the horizon for conversations as we keep moving forward. And then the 3 items that Jesse mentioned to add to the rulemaking package, if we can have a motion to proceed with those, Jesse will make sure that we don't miss anything, that we have a good red line available for you, and that we announce the rulemaking hearing so that members of the public are informed. Motion by Dr. Halbert to go ahead and add those additional 3 items, time limitations, being put into number of days instead of months, the 8 count item for boxing, and the weight class differential. Do we have a second?
Now, first, before we do that, now, Mr. Grove, your item, is that going to be included in the discussion? No?
I don't think it needs to for the rulemaking. I think
Okay.
it's something we can decide.
I'm going to tell him to try to get on the agenda for a later meeting.
All right.
And we have a second by Patrick Wren to go ahead and proceed with the research and add to the rulemaking hearing for the December meeting those 3 items. All those in agreement, please say aye.
Aye.
Any opposed? Hearing none, we have, I think, a good amount of work for the rulemaking hearing. It'll be a good thing. All good. The last item on the agenda, almost last, is the sunshine presentation. I'll leave it.
So we did have a PowerPoint every year. They do encourage all of our boards and commissions just to go over the laws they call the Sunshine Meeting Act or the Sunshine Act, just to make sure that it's just kind of a refresher. Unfortunately, we're having some technical issues, so I will just summarize some of it for you all. You all have been on the commission, should be aware of this. But there is the Public Meeting Act that requires that boards and commissions, such as yourself, essentially are not engaging in secretive acts, making decisions that could affect someone's rights in secret. Those acts are being done during public meetings. Certainly, they essentially just define a meeting as any time when one or more board members are getting together and discussing certain matters. Certainly, you all may encounter each other in public. You might encounter each other at different, if you went to a boxing match together, because we have commission members that go to these things. Obviously, you're allowed to discuss, what's happening in the match, but you can't discuss, commission business. Couldn't discuss, if there was a complaint that arose from it. Things related to that. So, certainly if you meet each other, if you have lunch or if you run into each other, that's a little bit different. But you just can't discuss commission business. Is the biggest. Those types of things have to be done during public meetings. And it doesn't include on-site inspection of a project or a program. So again, if you were inspecting something, if you're going to a boxing match, it doesn't have any type of chance encounter or things where you're meeting outside of the scope of commission business. And if we're going to be discussing things that take place during meetings, it needs to be either a regular meeting or a special meeting. And we actually post all of those online. So, we discuss things where USA Boxing or any other individuals want to appear and discuss commission business, they can do so at our regularly scheduled meetings. And we also had a recent law change that requires a public comment period. Most of our commissions have already been doing that, but we do have to require now at the end of our meeting a public comment period where members of the public are allowed to come and make comments on items on the agenda. Unless you wanted to make any comments. Obviously, we don't have individuals here that want to make public comment today, but certainly any meeting in the future, if someone wants to discuss something on the agenda, they couldn't necessarily discuss, their open case on our legal report, but they could discuss, other items such as gloves, amateur events, or just other, rules or things that they want to see for the, to further combat sports in the state of Tennessee. There are some exceptions to when things can be public meetings or can be discussed during public meetings. An executive session, if we're discussing any type of a lawsuit, that could be an executive session if someone was to sue the commission, said that the commission was, violating their rights. We could have an executive session for that and discuss the lawsuit. That wouldn't have to be done during a public meeting. That would be outside of it. And those types of the communications under the Public Meetings Act, that also covers electronic communications, phone calls, texts as well. So don't email or text each other commission business. That could still be considered a meeting under the definition of the law. And certainly if you have something that wants to be on the agenda, you can always email the executive director. That's the easiest way to kind of avoid that impropriety. If you hit reply all and said, I would like to add something to the agenda, that could be considered a public meeting. So it's much easier just to send it directly to the executive director. And there is some case law that does discuss, whether or not something could be fixed essentially by bringing it to light during a public meeting. If there was something happened where, if you did discuss something, outside of the scope of a meeting, could it be cured by then saying, we're going to go and put this on the record at a public meeting? There are some times where commissions have been sued and the court said that was okay to do it that way. But it's much easier during a public meeting instead of trying to fix it after. And we look at whether or not there's a public meeting. We look at whether it's notice was provided of that meeting as well. We have to make sure that there is notice of the public meeting, and any proposed action that could be taken at the meeting. That's why we have our agenda. We have to make sure that it's posted early enough with the time in advance to make sure that citizens are able to become aware of the meeting. And then we have to make sure it's in a location on the internet site to make sure it has notice of it. We also state at the beginning was well, so that way parties would have proper notice. Essentially, there are some penalties if we violate the Open Meetings Act. Any action that was taken outside of the scope of a meeting could be null and void. So if the commission were to discuss, potentially disciplining a promoter outside of the scope of a public meeting, so we do our legal reports on the record. But, if there was a situation where, you became aware of a violation and gave a call to another commission meeting and said, hey, we need to, revoke this person's license, that could become null and void at that point, trying to take that action. It has to be done during a public meeting. And there's also, if someone was to sue the commission to state that there was a violation of the Public Meetings Act, there could be costs associated with it, obviously defending a lawsuit, and then, potentially there are some penalties that happen if that is violated. Essentially, we just want to make sure that everything is done in the scope of an open meeting as required by law. If you have any questions about, what I guess would be included in in an open meeting or needs to be included during an open meeting, I think err on the side of caution to make sure you're not discussing things outside of the scope of it. It's easier just to, make sure that commission business is discussed during the actual meetings. And if you're, having meetings outside of the scope of that or an executive session, make sure that you're communicating with the executive director, something that's you're brought up on as part of the meeting or something that you're concerned about. But obviously, it's just easier to have that one-on-one communication, send that directly to the executive director, and then she can make that decision of, we'll put it on the agenda, we'll discuss it, or if it's something that's outside the scope of a public meeting, then I guess you could say that's probably outside the scope of it. But, some of our commissions, it's a little bit different because we do have events that are attended by commission members. So, we just need to make sure that we're careful not to discuss. Are there any questions? No, it's just and on the encourage us to go through the PowerPoints, not quite as entertaining. just hearing me talk. But that's I think the biggest thing is, obviously, if you had to come back and put it on the record during a legal meeting, that might be okay during some of the case law that's discussed, but it's just easier to err on the side of caution if possible. And that's really the last item that we have on the agenda. We do have our public comment period, as discussed. If there's no public comments that are to be made today, then we can kind of close that period.
Let me check real quick. Dana, do you have anyone participating through Teams that has any comments regarding the agenda or anything that they'd like to address at this time?
No.
Thank you. We have none. Thank you.
Our next meeting is scheduled for December 11. Is that correct, or is it?
I
earlier?
believe so. Give me a minute and I will check my agenda, but I think it's December the 11th. Is that first Monday?
Might be the.
December the 11th, that second, sorry. Yes, absolutely. We have no other commission business to take care of. If the members have any questions, anything else to discuss, I welcome that. Otherwise, we would need a motion to adjourn. Second,
Second that.
all in favor, thank you so much for your time. This was very, very productive. We will proceed for the December meeting and good information for the rulemaking package. So thank you.